So why was a former Speaker of the House, Marissa Dalrymple-Philibert, charged in relation to statutory declarations she made between 2015 and 2021? In this final part 2 of my video, looking at the Integrity Commission's investigation into that issue, I'll tell you what the Director of Investigations found and why the charges were laid. Thanks so much for being here courtside with me. I'm Dionne Jackson-Miller. Stay tuned. Alright, so I'm continuing to go through the Integrity Commission report on this issue. We're picking up where the report looks at how the vehicle was disposed of. The report says the director is in possession of evidence indicating that ownership of the vehicle was transferred on May 16, 2022. That's about 2 months after Mrs. Dalrymple-Philibert told the commission she wasn't the owner. The director also says he's in possession of evidence indicating that the application for transfer was signed by Mrs. Dalrymple-Philibert on May 11, 2022, and that the signed application was presented to the purchasers by her representative and handed over at her office in Falmouth, Trelawney. The report also looked at terms and conditions attached to the 20% duty concession that says that where a concession is used, claims for upkeep, allowance and traveling can only be made in respect of the most recent concession vehicle. Claims for upkeep and traveling in respect of any other vehicle will not be honored. So if you have 3 vehicles that had been bought at one time or another using a duty concession, you can only claim traveling for the newest one. The report went on to say that evidence provided by the Director of Human Resource and Administration at the Houses of Parliament indicates that from 2016, from the time Mrs. Dalrymple-Philibert was appointed as Speaker of the House of Representatives in 2020, motor vehicle allowances were paid to her, but not in accordance with relevant law, guidance, and/or procedures. The officer at the Houses of Parliament provided evidence that indicate, among other things, that upon her election as Speaker, Mrs. Dalrymple-Philibert would be eligible to be assigned a fully maintained government-owned motor vehicle. It said our records revealed that for a 2-month period, September 2020 to October 2020, she was not assigned a vehicle. During that period, she used a personal vehicle. This vehicle was owned by Agneta Cecile Vieira and was a Toyota RAV4. Her records reveal that due to her use of a personal vehicle, she became eligible for a motor vehicle allowance. In November 2020, she was assigned a 2014 Mitsubishi Pajero. On November 3, 2020, she wrote to the Clerk of the Houses indicating that she was applying for a 20% duty concession on a 2021 Toyota Hilux. Then the report goes into the discussion of the findings. The report says the following facts have been established and are not in issue. Mrs. Dalrymple-Philibert was required to file statutory declarations. They were filed. She obtained a 20% duty concession to buy a motor vehicle to be used in connection with her public duties. The benefit, the 20% duty concession, only accrued to Mrs. Dalrymple-Philibert in her capacity as Member of Parliament and no one else. Motor vehicle allowances could only have been properly claimed in respect of the vehicle acquired with the most recent duty concession, that's a Benz. Under the Customs Act, Mrs. Dalrymple-Philibert was required to retain ownership and possession of the vehicle for at least 3 years, and the motor vehicle formed part of her assets and should have been disclosed in her statutory declarations. So the questions raised by the director then are whether the omission of the vehicle amounts to her knowingly making a false declaration and whether the use of the 20% duty concession consistent with the terms and conditions. He looked at a number of issues: the proximity of acquiring the vehicle to the close of the filing period, which was December 31, 2015. He said the date on the certificate of title for the vehicle is October 29, 2015. It therefore stands to reason that this information would have been fresh in the mind of Mrs. Dalrymple-Philibert at least in early 2016 when the statutory declaration for 2015 became due. The fact that the vehicle was in Mrs. Dalrymple's sole name would also require her to be directly involved in the process of insuring the vehicle annually. Mrs. Dalrymple-Philibert featured prominently in the process of obtaining the duty concession and obtaining financing. The terms and conditions associated with the duty concession are clear and were provided to Mrs. Dalrymple-Philibert on at least 3 occasions: when she made the application for the concession, when she received the concession, and when she signed the customs declaration form. The funds to acquire the vehicle were provided by Mr. Lincoln Eatman by way of loan and cash deposit, and he also looked at Mrs. Dalrymple-Philibert's representations that the vehicle was neither owned nor operated by her, although it was acquired in her name and with the aid of a 20% duty concession obtained by her. The report then said, as it relates to whether the omission of the information about the Benz amounts to the making of a false statement in the statutory declarations, the director finds it could reasonably be inferred that a false statement was made in this regard, particularly for the 2015 filing period when the fact of the purchase would have been fresh in the mind of Mrs. Dalrymple-Philibert. The director looked at the terms and conditions, the representations made by Mrs. Dalrymple-Philibert in respect of who had custody and control of the vehicle, that is, that the vehicle was driven exclusively or almost exclusively by another person, that the vehicle was not used in connection with her duties as Member of Parliament, that motor vehicle allowances were not claimed on the vehicle, and he looked at representations made by Mrs. Dalrymple-Philibert through the clerk to the Houses of Parliament to the Ministry of Finance for a 20% duty concession to be granted. In light of all of the foregoing circumstances, the report says the director finds sufficient basis to infer that Section 36 of the Customs Act, together with other terms and conditions of the duty concession granted to Mrs. Dalrymple-Philibert, were breached. The report also says it's curious that the accounting and/or accountable officers at the Houses of Parliament did not discover that claims for motor vehicle allowances by Mrs. Dalrymple-Philibert were being made in breach of the relevant legislation and circular. He notes that the application for the 20% duty concession was made through the Houses of Parliament, so they therefore had actual or constructive knowledge of same, as well as the terms and conditions attached to it. Constructive knowledge is knowledge that you are legally presumed to have known, because you should have known it if you had done the basics in terms of due diligence. The report then goes to conclusions and recommendations. The director concludes that Mrs. Dalrymple-Philibert was legally obliged to file statutory declarations, that apart from the omission of the Benz, she discharged her obligation to file declarations for the period 2015 to 2021. That in relation to her omitting the Benz from her declarations, the director concludes that Mrs. Dalrymple-Philibert was the legal owner, and having omitted to include the Benz in her declarations were inaccurate and incomplete. The director concludes that there is sufficient basis to infer that the omission amounts to the offence of knowingly making a false declaration to the Commission. In relation to the 20% duty concession, the director concludes that both the terms and conditions to include Section 36 of the Customs Act were breached. The director finds that any person who assisted Mrs. Dalrymple-Philibert are equally liable. The director further concludes that consideration should be given to whether the concession was fraudulently obtained. The director concludes that motor vehicle allowances paid in spite of the breaches were irregular. The director concludes that in failing to identify the clear breaches identified, the accountable officer and/or accounting officer at the Houses of Parliament were negligent in processing payments made to Mrs. Dalrymple-Philibert. The director concludes that the failure on the part of the accountable officer constitutes a breach of Circular 13 and their duty under the Financial Audit and Administration Act. The director recommended that the report be referred to the Director of Corruption Prosecution for consideration. The director also recommends that the report be referred to the Commissioner of Customs to recover duties and apply any penalties as the Commissioner may deem to be appropriate. The Director recommends that the Clerk to the Houses of Parliament undertakes a review of the approval process for payment of motor vehicle allowances at the Houses of Parliament to ensure it is fit for purpose and fraud proof. The Director recommends that the report be referred to the Financial Secretary to take such action as may be necessary to recover allowances paid in breach of Circular 13 and the terms and conditions of the 20% duty concession. The Director recommends that the report be referred to the Prime Minister for him to take such disciplinary and/or administrative actions which both recognizes the seriousness of Mrs. Dalrymple-Philibert's conduct and to deter recurrence. The Director further recommends that a national training program be developed for members of Parliament in the area of ethics and the applicable government policies, regulations, and legislation. Of Investigation recommends that the Director of Information and Complaints requests that Mrs. Dalrymple-Philibert resubmit a complete and accurate statutory declaration as required by law. So the report then was referred to the Director of Corruption Prosecution, and the Director of Corruption Prosecution ruled that Mrs. Dalrymple-Philibert should be charged for 4 counts of breach of Section 15(1)(b) of the Parliament Integrity of Members Act 1973 for making a false statement in a statutory declaration for the periods ending December 31, 2015, February 25, 2016, December 31, 2016, December 31, 2017. It was also determined that Mrs. Dalrymple-Philibert should be charged for 4 counts of breach of Section 43(2)(a) of the Integrity Commission Act 2017 for making a false statement in a statutory declaration for the periods ending December 31, 2018, December 31, 2019, September 3, 2020, and December 31, 2020. And those 2 different acts are referenced because in 2015, when the issue started, the Integrity Commission Act at that time was not yet in effect, had not yet been passed by Parliament. So you have charges being laid under the old legislation and charges being laid under the new legislation. That brings us to where we are now. The matter is now before the court. The trial date that has been set is March 31, 2025. So I'll keep you up to date on what happens with this and other cases. Thank you so much for joining me courtside. I'm Dionne. I'll see you next time.